All right, so today I'm going to talk about copyright and artificial intelligence from the perspective of the U.S. Law and U.S. courts. As as both a lawyer and a creative person, I'm very invested in this space. I went to law school to work with creative people and to uh, help protect intellectual property rights. In addition to music, I make digital art, I write, I'm all over the place in terms of creative pursuits. And so again, as Valentine said, this is very personal for me as well as professional. So I'm happy to talk about all of these issues today as they pertain to the creative industries. So let's start off with a very high level. What is AI? What are we even talking about here? To the extent that folks aren't totally familiar with it, artificial intelligence as a concept is just a set of techniques that are aimed at approximating some level of human or animal cognition using machines. So that's kind of the broad overview. And as you drill down deeper into higher levels of complexity, you get to things like machine learning and deep learning, um, types of training computer algorithms that enable computers to learn without being explicitly programmed. And these are all using mathematical models that I could not begin to explain to you from a technological standpoint. And I think to some degree, those who develop them have a hard time explaining them. But essentially, they are highly complex algorithms used to analyze data and make predictions or decisions. Um, and then when you get into deep learning, this is a subfield of machine learning using neural networks. And again, this is a highly complex matrix of uh, connections that the computers are making between point A to point B to point Z. Um, and it allows them to undertake tasks like image and speech recognition, like the AI assistant we are talking about a few minutes ago on Zoom, identifying patterns, etc. Really, we end up talking about when we're talking about generative AI is this pattern recognition, kind of the prediction of what word comes next and what an image should look like. And so just in general, differentiating between just AI as a concept and in general application, like whether it's transcription or autocorrect or any number of apps or computer programs built into your phone, built into your laptop. There's AI everywhere. Generative AI, what we're going to be talking about today, is a subfield that quite literally generates content. That's why it's called generative AI. It's a type of artificial intelligence that allows the user to create output that seems human, whether that is text sounding like a human writing or a human talking to you, an image that looks like a photograph or looks like a painting of a recognizable thing or not, could be abstract too. When we're getting into music, generation of sound recordings, generation of sheet music, generation of lyrics, videos. Now there are what's called multimodal AI platforms where you can go image to video, text to video, video to text, and any number of permutations. So it's gotten very complex and very sophisticated very quickly. Um, I certainly will not read all of these different things to you, but this is just to give you an idea of how far the application of AI technology goes, all the way from banking and finance and online shopping to entertainment and hospitality. So it permeates pretty much every industry, and to the extent it hasn't yet, it will. So a lot of the legal questions that we'll talk about revolve around this concept of training data. And so the basic thing to understand is that AI models don't just learn on their own. They learn because they are trained on a massive amount of data. You have to feed data into the model so that it knows how to predict things. So this data can include the materials include images, videos, music, written materials, and what's really important is the metadata that goes along with it, including captions, and the associated text that says what it is. A picture of a cat that says cat, and when you type, tell Midjourney to make you a picture of a cat, it knows in theory what a cat is, because it can associate the image with the words. Now, there's a lot of debate over what and to what extent AI actually knows things as opposed to just mathematically predicts things. I think the general consensus is that there's certainly no real cognition. This is again a predictive engine that says, well, based on what I have analyzed, what is the logical next word in the sequence of words when you tell me to write a paragraph about an evil clown in the style of Stephen King? Okay, I know what a clown is, I know what evil is, and I know what the style of Stephen King is. So how would that sound? And it's predicting one word after the next. Um, Back to the legal issues, a lot of this content, if not all of the content, at least at the outset, was scraped from the internet, from publicly available websites. Now, some AI developers are using either licensed materials or quote clean data sets, things that they have permission for or that they generated in house, or in the case of companies like Shutterstock and some other stock content houses, materials from their contributors that they then made deals with contributors to use for new functions. But by and large, there's just a ton of internet material that's been scraped and just copied without permission, and has been fed into these models to create a usable product. And as I alluded to, what we're talking about here is mathematical representations of the content to teach the model how to form relationships and make predictions. Now, there's debate over, to what extent this material is memorized and still kind of lives within the black box that is the AI algorithm set. To what extent can it regurgitate it verbatim? That certainly has happened. And so these are all things that are not only percolating, I think, through the technology side of things, but also through the court cases. If you haven't used a Midjourney or a ChatGPT, it looks pretty simple on the front end. You come up with an idea, you type in a prompt, and it spits something out, and that's the output. Image, text, video, music, whatever it is that you're making, you will get something in response. Whether it's actually what you anticipated is another question. Just going to a couple of previewing some of the issues that we've been seeing, both in the courts and in the legislatures and in the public square in terms of debates. As I mentioned, data sets might not have been lawfully created. There's significant copyright issues and sometimes even trademark issues, as you'll see in some of the case law or some of the pending lawsuits. The data sets may contain depictions of people who haven't signed releases. So there's right of publicity and privacy issues, potentially. Biometrics and other state privacy violations. So there's some lawsuits dealing with those. I'm not going to touch on those because that's not my area of focus, but there are definitely other significantly concerning legal issues floating around. In terms of non-legal issues, the quality of the output might not be great. There's this whole garbage in, garbage out problem. If the model is trained on unhinged subreddit threads and 4chan, that's what you're going to get coming out of it. It's one of the reasons why those who are creating these models and training them want as much data as possible and as high quality data as possible, so that the output isn't unusable. And sometimes it hallucinates anyway; it makes things up. So you can't expect perfect output, at least not at this point. Um, the source of the input is sometimes not transparent. This goes kind of circles back to some of the copyright issues. And again, the garbage in, garbage out input could contain errors, could contain nonsense, could contain horrible, racist or misogynistic or whatever it is. The all the negative stuff you find out there is potentially going to be in there too, including bias. And then we get into the question of ethics. What are we doing here in terms of replacing jobs? Are people losing jobs because of this? The answer is yes. What's going to happen in terms of the labor force? Is what is created art? Is it literature? These are all very difficult questions that everybody's kind of grappling with at this point. These are some of the major players that we're seeing. DALL-E and Stability and Midjourney are image generators. Claude, Gemini, and Llama and ChatGPT, of course, are text generators. And then you've got companies like Sora. Well, Sora is a OpenAI product. It's a video generator, but stable audio. Again, getting into the music space, so there's a lot going on here. I won't read this to you, but this is one of my experiments with ChatGPT to draft a little summary for a CLE that I was doing. It often comes out as a little bit stilted, a little sterile. I didn't really understand the joke at the end. I asked it to make a lawyer joke, and it says, why don't lawyers go to the beach? Because cats keep trying to bury them. Anyone can explain that one to me, I'd be happy. Midjourney, just an example of some of the images that you can generate. The prompt gives you a little bit of insight into me. Red fire-breathing dragon in the style of 1980s Dungeons and Dragons. You can tell what I was doing when I was a kid. I use, they're beautiful images, and you can really do a lot with these platforms. This is just basically what stable audio looks like. You give it a prompt, what kind of music you want to hear. Is it pop? Is it synthesizers? Is it heartfelt? Is it a ballad? And over on the right is where you get your output. I don't think my video link works here, but you should check out. And actually, I'm not even going to try because you never know what happens with YouTube. You may want to give this a look. Check out the Sora demo. It's pretty. It's wow. It's pretty crazy. Oh no, that's not. Oh look, it did work. Oh, lucky you. Lucky you and lucky me that I don't have to fumble with trying to figure out how to unscrew this up. So this is an AI generated video from Sora. I don't know if there's text to video or what, but anyway, it's pretty wild. I will not go into great depth on copyright basics, but it will help give you a little bit of a foundation as to what we're talking about in a few minutes. But in the United States, essentially, copyright law is what applies to creative endeavors. Think about paintings and books and anything that is essentially the expression of an idea, not an idea itself. Copyright law does not protect ideas or concepts. It protects the expression of ideas. And under U.S. law, the expression of an idea to be copyrightable has to be fixed in a tangible medium that is perceivable for more than a small duration of time. And it has to be just minimally original. So you just didn't copy it directly from somebody. I mean, I could sit here and draw a stick figure, and in theory, it should be copyrightable as long as it's minimally creative and it came from me and I didn't copy anybody. What's counterintuitive is that to protect those rights, you have to register the work. You automatically own the copyright as soon as you fix the work, but you can't actually sue on it until you register it. I don't think that is true in any other country. So that's a little counterintuitive wrinkle there. Again, differentiate this from things like trademark and patent law. Trademarks cover brands and source identifiers to avoid consumer confusion about goods in the market. Patents is about inventions and ideas that are being implemented and into practice. Talking about science and technology, and those have to be novel as opposed to just original. So think about copyright, think about creativity, and that's where we sit. Okay, so let's talk about authorship. So I said the works have to be minimally creative, but minimally creative, what does that mean? And who's making it? So there's a debate going on now who should be considered the author of an AI generated work. So the questions to ask are, how is the AI being used? And is there any human input? So how much control does the user have over the final product? There is a lot of debate over this. I think at the current time, the law is fairly clear, but there are parties that are trying to challenge that in the U.S. And so here's where we get to the current status. So under the Constitution and under the U.S. Copyright Act, there's reference to authors. Authors is not a defined term, so that's where people are finding the wiggle room to say an author should include a machine, an author should include an animal, an author should include something else. But really where things stand right now, certainly with the Copyright Office and the current court rulings, an author has to be a human. The Copyright Office will not register a work if it determines that a human being did not create it. And it also won't register a work created by a machine or mechanical process that operates randomly or automatically without creative input or intervention. So that's the copyright compendium. It's really, if you want to sit down and read 1,200 pages on U.S. copyright practice, it's free online. Third version of the compendium, super helpful reference guide for U.S. copyright law and practices. The Copyright Office also issued guidance on its own policy statements of registering AI generated works, reaffirming that there's a human authorship requirement. If a work is generated solely in response to a prompt, the output is not copyrightable and technically is in the public domain. And the grounding for this is that users don't exercise control over the output. They are not the, quote, creative mastermind. The prompt could be copyrightable if it's long enough. If I just said, my favorite example to use, I don't know why, is a squirrel riding a bicycle, and I don't have my picture of the squirrel riding a bicycle from Midjourney today, but that prompt is a short phrase. It's not copyrightable, plain under the copyright law. If I write a paragraph describing the squirrel riding the bicycle in great detail, that paragraph could be copyrightable, but still the output from the AI machine is not. AI works will be protectable to the extent that there is human authorship added, and only to the extent that the human added authorship to it. The rest of it is still not copyrightable. So how to unscramble that egg is another question. And there are registration requirements in terms of how to fill out the forms when you're registering works with AI components. You have to disclaim those. It's not very complicated, but I won't go into it in any more detail here. Just to give you an idea of some of the case law that's out there. In the Ninth Circuit, which is out in California, there was a case involving this handsome gentleman here who took a photo of himself using a photographer's camera. Essentially, this came down to the monkey doesn't have standing in court, but there was kind of language in passing in the court decision about how it's not a human that we're talking about here, so there was no standing to sue for copyright infringement. Same thing has been determined with respect to living things like nature, works made from natural materials, not necessarily copyrightable. The applicability of copyright protection to machine generated works comes out of a case involving a photograph of Oscar Wilde from the Supreme Court in 1884. stating that photographs can be protected by copyright, and the use of mechanical process doesn't exclude copyright protection as long as there's some human intervention in terms of exercising creative control. So the props that were used in this picture, the lighting, the positioning of Oscar Wilde on the couch, all those things were determined by a human, and so the ultimate output was copyrightable. Some would say, how is that different from putting in the prompt? Right now, it just is. There's been no explicit, as far as I know, discussion, unless it came out in the one district court decision that I'll get to in a minute. But at this time, U.S. law differentiates between a camera and AI output. Sorry, we have a repetition of Burrow Giles here, but Urantia Foundation is another amusing case where parties believe that celestial beings drafted their book, but it was found that the compilation of those writings was copyrightable by humans. So again, the human intervention was the creative compiling and arranging of those passages, but even if the passages were written by aliens. Fowler versus Perlmutter is the case that I referenced a minute ago about what's kind of moving through the courts in terms of what is copyrightable output from a machine. And the plaintiff here was trying to overturn the Copyright Office's refusal to register this image on the right that came out of an AI engine that Dr. Thaler created. Currently, the district court agreed with the Copyright Office and denied the copyright, said the denial of copyright registration for a work without any human involvement was proper. Right now, that is on appeal in the United States Court of Appeals in DC. This case is kind of what started the ball rolling on the question of copyrightable output. It's a case involving a comic book where the images were created by Midjourney, but the text was written by a human, and the entire work was compiled by a human. So after initially granting protection, granting a registration, the Copyright Office reversed itself after it found out that this work was largely AI generated, and then only granted protection to kind of the overall work and the text, but not the images. Similar case here. This is much more recent. This image on the right was created with Midjourney, and the author, the creator, claims that it was the iterative process is creative enough to entitle him to a copyright, but the Copyright Office refused. And right now, it has moved on to the courts. So much like Dr. Fowler, Jason Allen is suing the Register of Copyrights, Shear Perlmutter, for the office's refusal to register his work. Move on to that. So again, kind of open questions here. Is prompting sufficient to allow protection of the output? How much change do you have to add to get a copyright? What happens with hybrid works? These are all open questions at the moment. I could talk for an entire day about fair use. This is one of the most complicated concepts in copyright law, probably the most complicated one, and is somewhat unique to the United States. Just so you have the background, there are 4 general factors that courts consider when determining whether something is a fair use. And a fair use just means it is a non-infringing use that one, even if the user did not obtain permission. So purpose and character of the use, is it commercial or is it not? And the courts have kind of folded in this question of whether the use was transformative over the years. The nature of the work, is it more factual or is it more creative? How much of the work was used, and does the allegedly infringing use impact the market value for the original work? This case, I'm going to go quickly through the cases because I don't think you need a full primer on the case law here, but Campbell versus Acuff Rose is a Supreme Court case that's really important because it is the foundation for this question of whether something's transformative or not. Did you add new meaning or message to it? Is it for a new purpose? This is the big question that I think is going to hang over a lot of the AI litigations is, what is transformative? So we can skip through here. Andy Warhol Foundation is the most recent fair use case involving a use of a print of a Prince photograph in the magazine publishing space. I frankly didn't find this to be all that helpful in terms of clarifying what fair use is, but it did bring more focus back to the fourth factor, which is the impact on the market. And so, in questions about whether this was commercial use, or you, essentially using it for the same purpose that the original was used for. So again, super high level overview of what we're talking about in fair use. And then the question is going to be, is generative AI different from any of these other contexts? And transformativeness and market substitution are really going to be the big questions here. Have the works been substituted by the AI output? Was the use of input material for training transformative? We don't know. There hasn't been a decision on that yet. We'll get into memorization. That's yet another open question about whether and to what extent these machines can memorize works. So there are 34 pending AI cases and counting. So as of a couple of days ago, there were 33. Another one was filed like yesterday or the day before. This is one of the original ones. Comes from the complaint. Give you some nightmare fuel for tonight. This kind of almost exact replica of this Getty Images photo of some soccer players, except in extremely disturbing modifications to their bodies here. Just an example of some of the things that are the basis of the lawsuits. And you got Getty Images versus Stability AI and Anderson versus Stability AI, which are visual image cases. So is Zhang versus Google. And those all deal with the input of artistic works for training of AI models. Is that infringement or is it not? And some of these cases also deal with the output. Is the output infringing? If the output is similar to what has gone in, does that make the AI developer liable? Has any credits been stripped away and things like that? Authors Guild and Alter, as a disclaimer, those are two of the cases that I'm working on behalf of the plaintiffs. These are plaintiffs are authors of text works, fiction. Authors Guild, our clients are fiction authors. Again, suing for the unauthorized use of training data, training materials, essentially taking all of their books and using them to train these AI models to be able to more accurately replicate human speech and have usable output that also could potentially usurp the market for our clients' works. Our cases are strictly input cases, so we're not litigating the question of whether the output itself is infringing, although the output is relevant to the question of fair use. And the New York Times is one of the ones that got a lot of press, similar allegations to ours. This is where you get into questions of regurgitation and verbatim copying. And this case also had some trademark aspects to it, as did Getty Images, because you have watermarks and things and trademarks showing up in the output. So key questions before the courts. As I mentioned, the big one is the use of this copyrighted material without permission to train generative AI models fair use? Who knows? There are, again, 34 cases. Some are class actions and some are not. One was set to go to trial, and I think a couple of months ago, and then for some reason the trial was canceled, and it's going back to some summary judgment process. So and that's Ross Intelligence versus Thomson Reuters versus Ross Intelligence. So who knows what's going to happen with that? One of the other questions that comes up is, are the works actually contained in the training data? Did copying occur? Were they copied, and are they in there? And is it important or is it meaningful that the materials were procured from pirated sites as opposed to just scraped from the internet? In my opinion, it is very significant. I don't think you can claim fair use when you've used stolen materials, but that's one of the things that is percolating through the courts. How does this concept of public good factor in? It's not mentioned in the fair use statute, but it comes up in the case law sometimes, in terms of whether something is transformative. And I can't answer the question of, what do you mean by public good? Is it general public good? AI is good for everyone, or is it public good with respect to, the discipline that we're talking about, the, writing and art and things like that. I mentioned before about whether the model itself is derivative of all input, whether its outputs are derivative. Again, that's a question that's come up and has been kind of on shaky ground in some of the cases, but I think it has survived to a certain degree in a more limited space. How common is memorization and regurgitation? Who actually is liable for this? The users are ones that are generating potentially infringing output, but the model developers are the ones that use the training data and have provided the platform. So there's questions on direct versus indirect liability. Is this question about copyright management information just refers to things like metadata, credits, author names? Were those things stripped away under the US's Digital Millennium Copyright Act? Is that a violation? And other basic questions like, where should we sue? Are we in the right jurisdiction and venue? Can the class be certified under the class action procedures? There's a lot to decide over the course of 34 cases, and I don't have the answers, but we should hopefully in the next year or two. So stay tuned.